Herlig, I want to welcome my good friend Catherine Zappone, Minister Zappone, to this House, and I want to indicate at the outset that, having listened to the speech that was given here earlier by Minister Harris, every word of it is something with which I agree, and every line of it is something which I think the public should be aware of, and I'll come back to that in a moment. I want to make a second point. I think that this referendum is by no means a foregone conclusion as to its passage. And I want to say that it is the middle ground of Ireland to which those who, like myself, favour repeal should address ourselves in the coming weeks. And therefore I echo what other speakers have said about the need to have a reasoned, calm and persuasive debate, and also to roll up our sleeves to achieve this. This is not like the situation that arose in relation to the marriage equality referendum. This is quite different. The extent and depth of opposition and the issues involved are radically different. There are some similarities, but there are significant differences, and it will not go through on the nod, and it requires to be delivered politically in a rational, calm and decent way that brings Middle Ireland with the proposal. And in that context, I just want to say one thing. Words were spoken here about the Catholic Church in the 1960s and the abuses of children and the like. We cannot make the Catholic Church the enemy in this process. There are many, many good people who have devoted their lives totally to the Catholic Church, and they shouldn't be forgotten. Secondly, I want to say this, that those members in this House who are opposed to this referendum, they aren't anti-democratic if they vote against having a referendum. And I ask this House to remember in particular those who, I believe, wrongly said that they would allow the bill to abolish this House to go through, but only so that the people could have their say on the matter. That isn't the process. The Constitution remains the same until the Oireachtas proposes a change to the people. And if you're opposed to a change, you're entitled to vote against a change. Now, I just want to say one other thing. Others here have spoken extremely eloquently in relation to the dilemma of girls and women who find themselves having to make the decision whether or not to procure a termination of their pregnancy. But I want to emphasise one thing. If you look at Article 40 of the Constitution, and sometimes people don't actually look at the Constitution as we heard today, but if you look at the Constitution carefully, it is an article to do with personal rights. And the issue here is not whether a fertilised ovum in a petri dish, in an in vitro fertilisation clinic, is a human life. In one sense it is, in the same sense that an acorn is tree life in one sense. But an acorn is not a tree. And likewise, a fertilised ovum is not a person, a human person, from most people's point of view. It is the means whereby a person could, after a pregnancy, come into existence. And the reason that I mention that is we're dealing here with personal rights. And I believe that the mistake that was made and the error that Peter Sutherland counselled against in 1983, the mistake was to create an absolute black and white description of the distinction between potential life and a human person in circumstances where, as the leader has just said, there is a grey area. Can I also say that I believe very, very strongly that once the possibility of pharmaceutical abortion, pharmaceutical termination of pregnancy came about, a totally different situation was created. The state cannot, in fact, prevent it. And the state cannot really, realistically, put people on trial for getting such a tablet online or administering it to themselves. And we have to face up to a situation whereby we face the truth of what the Article 43.3 has done to us. Let's remember that in the X case, a victim of a rape was told by the Supreme Court that according to the Article 43.3 as it originally stood, she could be restrained by injunction from travelling out of the state to have an abortion in Britain, and that it was only the fact that she was suicidal that overrode her right to travel to Great Britain. That was what the X case was about. And I remember in particular my good friend, the late Éireann Hardiman, when he was a barrister at the time, saying on television that travel injunctions would follow from the Eighth Amendment if it became law. And he was told by a leading academic, who I won't mention now, but you can all guess who it is. He was told that this was fanciful and was effectively a scare story. But it came into existence in the X case decision. The Supreme Court said there could be travel injunctions, and the only thing that could override it was to avoid a threat of suicide or another threat to the life of a mother. Now, I just make that point here because I think it's important that we put into place in the Constitution what I consider to be, in retrospect, a fundamental untruth, and that was that the fertilised ovum, or after 4 weeks, a group of cells which are the size of your fingernail, or after 8 weeks, maybe the size of a finger, is a person with exactly the same rights as a mother, and the only circumstance in which one can prevail over the other is if there is a threat to the mother's life. That was creating, I believe, a constitutional untruth. And can I go one stage further and say, the excuse that was offered by that prominent academic and all those who supported the 1983 referendum for bringing it in is that we could not trust the judges not to impose in Ireland a Roe and Wade outcome. And now they're saying you can't trust the politicians either. Well, who can you trust if you won't trust the organs of a democracy to deal with a complex situation of this kind? So can I finish then by simply saying this clearly? This referendum is not a foregone conclusion. It cannot be left to the extremists or the most ardent people to make the arguments. It is to the middle ground that the arguments must be addressed, and it must be by people who sound reasonable and supportive and confidence-building to those who occupy the middle ground in the coming debate. And the arguments that are, in my view, very, very strong for appeal, and they go the whole way back to Éireann Hardiman and Peter Sutherland and all the rest of it as to why the Eighth Amendment was a mistake. Those arguments are very, very valid, but they have to be articulated in a way that brings people with them. And if we can't trust the judiciary as a democracy, and we can't trust the politicians as a democracy, and we can't even trust the women of Ireland in relation to the choices they must make, who are we to trust? And I believe we should have the courage to stand up and ask the Irish people to trust themselves, to give to the politicians they elect and the judiciary that they have indirectly appointed the control and the right to legislate in an area which is grey and in an area which, if it's dealt with as black and white, produces falsehoods, injustice and cruelty on occasions. And to those who say that Savita, and I have to say this in relation to what Senator Mullins said, that Savita Halappanavar's position was simply to do with sepsis, it was not. Because if it was simply that, and I make this point, what were they doing monitoring fetal heartbeat? Why was that relevant to the sepsis issue? It was more than that. Okay. Thank you very much.
Thanks, Senator. Senator Kelleher, you have 8 minutes.
I'm speaking today in support of passing the 36th Amendment of the Constitution Bill. I'm supporting its passage, and I hope you will too. I support this bill because 35 years after